Minnesota real estate property management questions. Question 1. A parcel borders a non-navigable stream. Rights connected to that water are commonly called what for Riley in Mankato involving a lake cabin priced at $407,500? Option A. Riparian rights. Option B. Literal rights only. Option C. Emblement rights. Option D is subrogation rights. The correct answer is option A. Riparian rights. Riparian rights relate to land adjoining rivers or streams. Literal rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 2. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Jordan in Minneapolis involving a single-family home priced at $391,000? Option A. Keep the entire deposit automatically as a cleaning fee. Option B. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option C. Apply the deposit to the broker's commission. Option D. Record the deposit with the county as a deed restriction. The correct answer is option B. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 3. Which fiduciary duty requires a broker to keep client money and property properly accounted for Rowan in Edina involving a single-family home priced at $227,000? Option A. Assemblage. Option B. Accretion. Option C. Accounting. Option D. Devolution. The correct answer is option C. Accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 4. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Reese in Woodbury involving a lake cabin priced at $323,000? Option A. It is always protected opinion regardless of knowledge. Option B. It is allowed if the buyer gets a loan. Option C. It becomes legal if stated verbally instead of in writing. Option D. It is a factual misrepresentation about a material property condition. The correct answer is option D. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 5. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Avery and St. Cloud involving a rental house priced at $259,000? Option A. Amortization. Option B. Accretion. Option C. Subordination. Option D. Cheat. The correct answer is option A. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and cheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 6. A seller instructs the licensee not to disclose a known structural defect to buyers, which principal controls for Harper in Northfield involving a fourplex priced at $207,500? Option A. The licensee must obey every instruction from a client. Option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option C. The defect becomes confidential forever. Option D. The buyer's broker alone must discover every defect. The correct answer is option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 7. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Finley and Eden Prairie involving a vacant lot priced at $391,000? Option A, blockbusting. Option B, estoppel certificate. Option C, legal non-conforming use. Option D, defeasible fee only. The correct answer is option C, legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation, estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 8. What is the main purpose of an owner's title insurance policy for Hayden Okafor? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D, to protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 9. When Blair, a licensee, intends to buy a client's property in Bemidji, what disclosure is required before negotiation or consummation? Option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option B. The licensee may stay silent if paying full market value. Option C. The disclosure is needed only after the deed is recorded. Option D. Only the buyer's lender must be told about the license. The correct answer is option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 10. A deed is signed by the grantor but never delivered to Rowan Lee. Why is delivery important? Option A. Delivery sets the mortgage interest rate. Option B. Delivery shows the grantor's intent that the deed take effect. Option C. Delivery replaces legal description requirements. Option D. Delivery creates a leasehold only. The correct answer is option B. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 11. Which ownership estate gives Morgan Patel the greatest bundle of rights with no stated end date or condition? Option A. Estate at sufferance. Option B. Life estate. Option C. Fee simple absolute. Option D. License. The correct answer is option C, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 12. If Jordan passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required for Jordan in Minneapolis involving a single-family home priced at $319,000? Option A, 30 days from passing the examination. Option B, 3 years from passing the examination. Option C, until the next broker renewal cycle only. Option D, 1 year from passing the examination. The correct answer is option D, 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 13. Before Taylor schedules the salesperson examination after studying in Northfield, which pre-license course must already be completed? Option A, Course I. Option B, Course 2 only. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option A, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 14. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Moorhead office for Sawyer in Moorhead involving a rental house priced at $266,000? Option A. Let each salesperson approve their own contracts without broker review. Option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option C. Delegate all trust records to buyers and sellers. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 15. A Bemidji salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper for Emerson in Bemidji involving a vacant lot priced at $217,500? Option A. Personal funds must always be kept in the listing broker's trust account. Option B. Salespersons may use trust accounts as savings accounts with broker consent. Option C. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option C. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 16. A lender offers Riley Kahn a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A. Package mortgage only. Option B. Open-end listing. Option C. Graduated lease. Option D. Adjustable rate mortgage. The correct answer is option D. Adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 17. Two brokerages agree that one will work only north of Woodbury and the other only south. What antitrust violation may this suggest? Option A. A market allocation. Option B. Redemption. Option C. Assemblage. Option D. is subrogation. The correct answer is option A. Market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 18. A zoning ordinance limits building height in Mankato. What government power is most directly involved? Option A. Eminent domain. Option B. Police power. Option C. This cheat. Option D. Taxation only. The correct answer is option B, police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 19. Which deed gives Kendall Patel the broadest set of title warranties from the grantor? Option A, quitclaim deed. Option B, bargain and sale deed with no covenants. Option C, general warranty deed. Option D, tax certificate only. The correct answer is option C, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 20. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used for Finley and Eden Prairie involving a vacant lot priced at $242,500? Option A, rectangular survey only. Option B, monumentless description. Option C, front foot appraisal. Option D, lot and block. The correct answer is option D, lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 21. A utility company has the right to run power lines across a Winona parcel. Which property right is usually involved? Option A, easement in gross. Option B, the state for years. Option C, divulsion. Option D, a remainder interest. The correct answer is option A, easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 22. If one broker represents both Cameron Peterson and Quinn Chen in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. All parties must give informed consent to the dual agency relationship. Option C. The broker may proceed without consent if the commission is reduced. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option B. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 23. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Rowan and Edina involving a mixed-use property priced at $338,500? Option A, eminent domain. Option B, literal rights. Option C, escheat. Option D, subordination. The correct answer is option C, escheat. Escheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking, literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 24. If Taylor Wilson tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, keep the information confidential until the closing date. Option B, cancel the agreement without telling the buyer. Option C, disclose only if the seller misses a loan contingency. Option D, immediately disclose the stated intent not to perform to the other party or parties. The correct answer is option D, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 25. A $433,000 sale carries a 6.5% commission. What is the total commission before any split? Option A, $28,145. Option B, $86,600. Option C, $10,392. Option D, $7,621. The correct answer is option A, $28,145. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 26. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Blair and Stillwater involving a condominium unit priced at $211,500? Option A, cost approach only. Option B, sales comparison approach. Option C, income approach only. Option D, front foot method only. The correct answer is option B, sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 27. A lot has 195 front feet worth $130 per front foot. What is the indicated front foot value? Option A, $930. Option B, $26,600. Option C, $25,350. Option D, $353,846. The correct answer is option C, $25,350. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 28. A salesperson discovers an error in an advertisement after publication. What is the most professional next step for Riley in Mankato involving a mixed-use property priced at $398,500? Option A, ignore it because errors in ads never matter. Option B, blame the buyer publicly. Option C, delete all transaction records. Option D, promptly correct the advertisement and notify the broker according to office procedures. The correct answer is option D, promptly correct the advertisement and notify the broker according to office procedures. Advertising must be accurate and compliant, so prompt correction and broker notification are appropriate. Ignoring errors, blaming clients, or deleting records creates greater compliance risk. Professional practice requires correction and documentation. Question 29. Why should a purchase agreement for a farm parcel in Eden Prairie be in writing and signed by the party to be charged? Option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option B. All oral contracts are criminal offenses. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 30. During a St. Paul license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Taylor and St. Paul involving a rental house priced at $346,000? Option A, 10 hours every 4 years with no annual deadline. Option B, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option B, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 31. A neighbor receives permission to park on Quinn Nguyen's land for one weekend only. What interest is most likely created? Option A, easement appurtenant. Option B, fee simple estate. Option C, license. Option D, a mechanic's lien. The correct answer is option C, license. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land, fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 32. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Cameron in Maple Grove involving a rental house priced at $338,000? Option A, riparian rights. Option B, deed restrictions. Option C, remainders. Option D, trade fixtures. The correct answer is option D, trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 33. A lender draws a line around a Winona neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Blair and Stillwater involving a vacant lot priced at $196,500? Option A, redlining. Option B, plottage. Option C, accretion. Option D, estoppel. The correct answer is option A, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 34. A buyer pays 1.5% in discount points on a $290,250 loan. Approximately how much are the points? Option A, $1,451. Option B, $4,354. Option C, $32,250. Option D, $19,350. The correct answer is option B, $4,354. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 35. After passing the examination, Casey wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Casey in Duluth involving a farm parcel priced at $416,000? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Option D. No additional education is needed once the exam is passed. The correct answer is option C. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 36. A parcel borders a lake near Minneapolis. Rights associated with use of the lake shore are commonly called what for Jordan in Minneapolis involving a lake cabin priced at $235,000? Option A, riparian rights only. Option B, fixture rights. Option C, novation rights. Option D. Literal rights. The correct answer is option D. Literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 37. A broker tells competing firms to keep commissions at the same percentage in Moorhead. What legal risk is most obvious for Sawyer in Moorhead involving a duplex priced at $413,500? Option A. Price fixing under antitrust law. Option B. Accretion. Option C. Constructive eviction. Option D. Functional obsolescence. The correct answer is option A. Price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 38. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Sawyer in Moorhead involving a fourplex priced at $357,000? Option A. Tie-in arrangement. Option B. Highest and best use. Option C. Novation. Option D. Steering. The correct answer is option B. Highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 39. In a dual agency situation in Eden Prairie, why must the licensee avoid advocating exclusively for one party for Finley in Eden Prairie involving a condominium unit priced at $435,500? Option A. The broker becomes a government mediator. Option B. The buyer automatically becomes the broker's only client. Option C. The broker owes duties to both buyer and seller within the limits of dual agency. Option D. The seller's broker relationship disappears at acceptance. The correct answer is option C. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 40. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat that issue for Parker in Eagan involving a newly built townhouse priced at $376,500? Option A. It is always a material defect in the property. Option B. It requires a separate appraisal license. Option C. It makes the deed void. Option D. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. The correct answer is option D. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 41. If an override clause appears in Morgan Johnson's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A. A protective list. Option B. A new deed. Option C. A county tax appeal. Option D. A mortgage payoff statement. The correct answer is option A. A protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 42. A title search finds an unpaid mechanics lien recorded against a Red Wing property. Why does this matter to a buyer for Drew and Red Wing involving a single-family home priced at $261,000? Option A. It proves the buyer has already paid cash. Option B. It may be an encumbrance affecting title and closing requirements. Option C. It automatically creates a condominium. Option D. It removes all property taxes. The correct answer is option B. It may be an encumbrance affecting title and closing requirements. A mechanic's lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 43. A social media ad for a vacant lot in Bloomington uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. Only the property street address. Option C. The real estate brokerage name. Option D. Only the team logo without the brokerage. The correct answer is option C. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 44. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Finley and Eden Prairie involving a farm parcel priced at $346,000? Option A. Accretion. Option B. Estoppel. Option C. Substitution principle. Option D. Tie-in arrangement. The correct answer is option D. Tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 45. A Granite Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Parker and Egan involving a newly built townhouse priced at $362,000? Option A. Yes, access to required statutes and rules may be made available electronically. Option B. No, only a paper binder signed by every buyer is allowed. Option C. Yes, but only if clients pay a records fee. Option D. No, statutes are never required in real estate offices. The correct answer is option A. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 46. A buyer includes an inspection condition in a Red Wing purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 47. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Casey in Duluth involving a vacant lot priced at $374,000? Option A. Personal income withholding tax. Option B. Sales tax on furniture. Option C. Mortgage registry tax. Option D. Special assessment appeal fee. The correct answer is option C. Mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 48. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Morgan in Rochester involving a townhome priced at $382,500? Option A. A guaranteed appraisal. Option B. A material title defect. Option C. A deed restriction. Option D. Puffing if it is clearly opinion rather than a factual claim. The correct answer is option D. Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 49. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Harper in Northfield involving a rental house priced at $448,500? Option A. Compensation is determined between each individual broker and the broker's client. Option B. The state sets one mandatory commission rate for all residential listings. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option A. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 50. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Parker and Egan involving a newly built townhouse priced at $397,500? Option A. Gross rent multiplier. Option B. Meets and bounds. Option C. Capitalization rate. Option D. Straight line depreciation. The correct answer is option B. Meets and bounds. Meets and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 51. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Harper in Northfield involving a rental house priced at $316,000? Option A. The broker must personally investigate every nearby resident. Option B. The broker must guarantee no offenders live in the city. Option C. The broker has no duty to disclose specific registry information beyond the required notice. Option D. The broker must cancel the purchase agreement automatically. The correct answer is option C. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 52. A borrower signs a promissory note and mortgage to finance a Winona home. What does the note do for Hayden in Winona involving a small retail building priced at $369,500? Option A. Transfers title to the lender at closing. Option B. Sets the zoning classification. Option C. Records the deed tax payment. Option D. Creates the borrower's personal promise to repay the debt. The correct answer is option D. Creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 53. Two investors own a St. Paul duplex with unequal shares and no survivorship language. Which ownership form is most likely for Taylor in St. Paul involving a rental house priced at $225,500? Option A. Tenancy in common. Option B. Tenancy by the entirety. Option C. Severalty. Option D. Life tenancy only. The correct answer is option A. Tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life tenancy by the entirety is a special marital form not described by unequal investor shares. Question 54. A sudden flood removes soil from a riverbank in Washington County. What term describes the sudden loss for Kendall and Blaine involving a newly built townhouse priced at $401,500? Option A, accretion. Option B, divulsion. Option C, assemblage. Option D, plottage. The correct answer is option B, avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 55. A licensee in Eden Prairie drafts a complex legal clause for Quinn Davis instead of recommending legal counsel. What risk is created? Option A, constructive eviction. Option B, of functional obsolescence. Option C, unauthorized practice of law. Option D, inverse condemnation. The correct answer is option C, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 56. An advertisement says a small retail building is available only for adults with no children. What is the main fair housing concern for Kendall and Blaine involving a small retail building priced at $238,500? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The ad includes the city name. Option D. The statement indicates a preference or limitation based on familial status. The correct answer is option D. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 57. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Drew and Red Wing involving a mixed-use property priced at $280,000? Option A, Minnesota Statutes Chapter 82. Option B, Minnesota Statutes Chapter 287 only. Option C, the Federal Internal Revenue Code only. Option D, a local MLS policy manual only. The correct answer is option A. Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 58. In Rochester, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Morgan in Rochester involving a small retail building priced at $428,500. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option C. Complete continuing education before any pre-license education and apply directly without a broker. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option B. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 59. A rumor says a St. Paul home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated for Taylor in St. Paul involving a duplex priced at $442,000? Option A. It must always be disclosed in the listing contract. Option B. It makes the property unmarketable until court approval. Option C. It is not treated as a material fact that must be disclosed merely for that reason. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option C. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 60. During a first substantive contact with a residential consumer in Red Wing, what disclosure should the licensee provide for Drew in Red Wing involving a mixed-use property priced at $398,000? Option A. A final closing disclosure showing loan terms. Option B. A county tax statement for the current year. Option C. A deed prepared for recording. Option D. An agency disclosure form explaining available agency and facilitator relationships. The correct answer is option D. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 61. A St. Paul salesperson asks whether Minnesota state law or a private study guide controls if they conflict. Which source governs for Taylor in St. Paul involving a duplex priced at $316,500? Option A. Minnesota law governs the licensing issue. Option B. The private study guide controls if newer. Option C. A salesperson's office custom controls. Option D. The buyer's preferred answer controls. The correct answer is option A. Minnesota law governs the licensing issue. Official guidance makes clear that Minnesota law governs licensing issues. Study guides and office customs are learning tools or business practices, not controlling law. A buyer's preference cannot override statutory requirements. Question 62. In appraisal, what does highest and best use require for Rowan in Edina involving a lake cabin priced at $250,000? Option A. The use that produces the highest commission. Option B. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Option C. The use preferred by the current tenant only. Option D. The use with the lowest property tax bill. The correct answer is option B. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 63. A buyer representation agreement in Brainerd is best described as what type of document for Schuyler in Brainerd involving a townhome priced at $363,500? Option A. A deed transferring title to the buyer. Option B. A loan commitment from the lender. Option C. A written contract that creates agency representation for the buyer. Option D. A property tax statement from the county. The correct answer is option C. A written contract that creates agency representation for the buyer. A buyer representation agreement is the written contract that creates buyer agency. It does not transfer title, approve financing, or state county taxes. Representation contracts define the broker-client relationship and compensation terms. Question 64. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Sawyer and Moorhead involving a rental house priced at $235,000? Option A, stay silent because the report always controls. Option B, destroy the report and order a new one. Option C, tell only the inspector after closing. Option D, disclose known facts that contradict the report. The correct answer is option D. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 65. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Morgan and Rochester involving a newly built townhouse priced at $463,500? Option A, status with regard to public assistance. Option B, preference for a short commute. Option C, owning two vehicles. Option D, having a fixed-rate mortgage. The correct answer is option A, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 66. A built-in dishwasher is attached and adapted to a vacant lot. What is it most likely considered in a sale for Quinn in Bloomington involving a vacant lot priced at $452,000? Option A, emblement. Option B, fixture. Option C, trade name. Option D, license. The correct answer is option B, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 67. A licensee directs families with children only toward one area of Bloomington. What fair housing problem does that conduct create for Quinn in Bloomington involving a condominium unit priced at $233,000? Option A, amortization. Option B, subordination. Option C, steering. Option D, novation. The correct answer is option C, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 68. A broker learns that a foundation defect could significantly affect Skylar Patel's use of a townhome in Eagan. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, treat the defect as confidential even if it affects use and enjoyment. Option D, disclose the material fact to the prospective purchaser. The correct answer is option D, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 69. A facilitator working with Hayden and Eagan performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, confidentiality. Option B, loyalty to the seller only. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option A, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 70. Why is the Minnesota agency disclosure form given to Cameron Rivera not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 71. A deed expressly creates survivorship between co-owners of a lake cabin. Which ownership feature is being emphasized for Jordan in Minneapolis involving a lake cabin priced at $385,000? Option A. No right to possess the property. Option B. A tenant's trade fixture right. Option C. Right of survivorship in joint tenancy. Option D. A mortgagee's foreclosure priority. The correct answer is option C. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 72. While interviewing with two firms in Minneapolis, Riley asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. Any number of brokers if the salesperson discloses the arrangement. Option C. 1 broker for residential sales and a separate broker for leases. Option D. 1 actively licensed broker. The correct answer is option D. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 73. A Stillwater buyer's loan has small monthly payments but 1 large final payment. What is that final payment called for Blair in Stillwater involving a vacant lot priced at $432,000? Option A. Balloon payment. Option B. Proration credit. Option C. Replacement reserve. Option D. Equity dividend. The correct answer is option A. Balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing. A replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 74. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Casey in Duluth involving a farm parcel priced at $358,000? Option A. The buyer is automatically a client forever. Option B. The buyer is a customer unless and until a written representation contract is signed. Option C. The buyer becomes the broker's employee. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option B. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 75. A rental property produces $62,000 in net operating income and investors require a 7% capitalization rate. What value is indicated by the income approach? Option A, $166,750. Option B, $282,600. Option C, $885,714. Option D, $19,200. The correct answer is option C, $885,714. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 76. Which document is used to convey ownership of real property from grantor to grantee for Hayden in Winona involving a newly built townhouse priced at $242,500? Option A, promissory note. Option B, listing presentation. Option C, home inspection checklist. Option D, deed. The correct answer is option D, deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 77. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Schuyler and Brainerd involving a small retail building priced at $446,000? Option A. A lien securing repayment while the borrower retains title. Option B. Immediate ownership and possession of the property. Option C. A life estate measured by the borrower's life. Option D. A leasehold estate for the loan term. The correct answer is option A, a lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 78. If a seller rejects Finley Miller's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. No later than the next business day after rejection. Option C. At the end of the listing period. Option D. After the broker deducts marketing expenses. The correct answer is option B. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 79. Why might Parker Davis use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It creates a new mortgage automatically. Option C. It transfers whatever interest the grantor may have without making title warranties. Option D. It replaces the need for delivery and acceptance. The correct answer is option C. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 80. A garage built on Quinn Lee's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A. Hypothecation. Option B. Subrogation. Option C. Reconciliation. Option D. Encroachment. The correct answer is option D. Encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 81. If annual property taxes of $5,800 are prorated to the seller for 209 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $3,321. Option B, $31,885. Option C, $6,149. Option D, $1,879. The correct answer is option A, $3,321. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 82. A legal description refers to township, range, and section. Which survey system is being used for Taylor in St. Paul involving a rental house priced at $196,500? Option A, meets and bounds only. Option B, rectangular government survey system. Option C, lot and block only. Option D, a gross lease system. The correct answer is option B, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 83. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Drew and Red Wing involving a lake cabin priced at $340,000? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson automatically becomes a limited broker. Option C. The salesperson's license becomes inactive until proper association is restored. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option C. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 84. A city takes private land for a public road after paying just compensation. What power is being exercised for Hayden and Winona involving a small retail building priced at $221,000? Option A, is cheat. Option B, adverse possession. Option C, police power only. Option D, eminent domain. The correct answer is option D, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 85. A salesperson tells owners in St. Cloud to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Avery in St. Cloud involving a rental house priced at $392,500? Option A, blockbusting. Option B, reconciliation. Option C, hypothecation. Option D, assemblage. The correct answer is option A, blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 86. A Minnesota salesperson renewal fee includes a contribution to which fund for Sawyer and Moorhead involving a fourplex priced at $408,500? Option A, Federal Flood Insurance Reserve. Option B, Real Estate Education, Research and Recovery Fund. Option C, County Recording Technology Fund only. Option D, Private MLS Scholarship Account. The correct answer is option B, Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 87. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Jordan in Minneapolis involving a lake cabin priced at $404,500? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 3 business days of receipt or final acceptance, whichever is later. Option D. Within 30 calendar days after the first showing. The correct answer is option C. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 88. During negotiations in Red Wing, Riley Nolan changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It keeps the original offer open forever. Option D. It is a counteroffer that rejects the original offer and proposes new terms. The correct answer is option D. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 89. An easement benefits a neighboring parcel by allowing driveway access across Cameron Miller's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 90. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Rowan in Edina involving a lake cabin priced at $352,500? Option A. Adverse possession. Option B. Reasonable accommodation. Option C. Yield spread premium. Option D. Defeasance clause. The correct answer is option B. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 91. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Parker and Egan involving a newly built townhouse priced at $308,500? Option A. A verbal request from one salesperson. Option B. A social media announcement that the deal is done. Option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D. The buyers hope to renegotiate after closing. The correct answer is option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 92. A St. Paul parcel contains 6 acres. How many square feet are in the parcel? Option A. $11,050. Option B. $199,500. Option C. $6,412. Option D. $261,360. The correct answer is option D. $261,360. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 93. At Riverbend Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Parker and Egan involving a townhome priced at $301,000. Option A, Pulse. Option B, MLS Grid. Option C, Torrens Online. Option D, HUD Exchange. The correct answer is option A, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 94. When Rowan Miller buys a condominium unit in Mankato, what does the buyer typically own for Riley in Mankato involving a lake cabin priced at $349,500? Option A. Only a stock certificate and no real property interest. Option B. The individual unit plus an undivided interest in the common elements. Option C. The entire building in severalty. Option D. A temporary license to occupy the unit. The correct answer is option B. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 95. If a Northfield property sells for $430,500 and the buyer obtains an 75% loan, what is the buyer's down payment? Option A, $322,875. Option B, $26,906. Option C, $107,625. Option D, $859. The correct answer is option C, $107,625. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 96. Why would an appraiser rely heavily on the cost approach for a newly built small retail building in Rochester? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. It values the property only by monthly rent. Option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The correct answer is option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 97. If Finley fails to complete required continuing education by the renewal deadline, what license consequence can occur for Finley in Eden Prairie involving a condominium unit priced at $277,500? Option A. The license can become inactive. Option B. The license automatically converts to a broker license. Option C. The license becomes a deed restriction. Option D. The license renews for free without further action. The correct answer is option A. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 98. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Casey in Duluth involving a vacant lot priced at $356,000? Option A. Say nothing because relatives are not licensees. Option B. Disclose the relationship in writing before negotiating or consummating the transaction. Option C. Disclose only after the commission is paid. Option D. Ask the lender to disclose it instead. The correct answer is option B. Disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 99. A deed gives Reese possession for life, then ownership passes to Rowan Lee. What interest does Rowan Lee hold before Reese's death? Option A, leasehold estate. Option B, easement in gross. Option C, remainder interest. Option D, mortgage lien. The correct answer is option C, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 100. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Blair in Stillwater involving a farm parcel priced at $416,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To eliminate the need for title insurance. Option D. To allocate income or expenses to the party who owned the property during the relevant time period. The correct answer is option D. To allocate income or expenses to the party who owned the property during the relevant time period. Prorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation.